Alright, gotta clear my throat here. This is Joe Nappy, and I'm recording my Supreme Court Cases iBook. Let's do this. In Miranda v. Arizona, the Supreme Court overturned Miranda's conviction, saying that his 14th Amendment right not to be deprived of liberty without due process of law had been violated. So he got a break on that one. In Roe v. Wade, the court held that, in regard to abortions during the first trimester, the decision must be left to the judgment of the pregnant woman's doctor. So Roe won that one. In Texas v. Johnson, the First Amendment specifically disallows, I didn't know that was a word, the abridgment of speech, in quotes, but the court reiterated its long recognition that its protection does not end at the spoken or written word. So burning a flag is allowed. Okay, in Atkins v. Virginia, in a 6-3 opinion delivered by Justice John Paul Stevens, the court held that executions of mentally retarded criminals are cruel and unusual punishments prohibited by the Eighth Amendment. Okay, Seahawks are playing Arizona Cardinals. It's quite an intense game, so you might hear that in the background. In a 5-4 opinion delivered by Justice Anthony Kennedy regarding Roper v. Simmons, the court ruled that standards of decency have evolved so that executing minors is cruel and unusual punishment prohibited by the Eighth Amendment. I don't know what standards of decency have to do with any of that, but there you go. Duncan v. Louisiana. In 7-2 decision, the court held that the Sixth Amendment, guaranteed of trial by jury in criminal cases, was fundamental to the American scheme of justice, a scheme, and that the states were obligated under the 14th Amendment to provide such trials. In Lee v. Wiseman, in a 5-4 decision, the court held that government involvement in this case created a state-sponsored and state-directed religious exercise in public school. In U.S. v. Miller, the Supreme Court reversed the district court, holding that the Second Amendment does not guarantee an individual the right to keep and bear a sawed-off double-barrel shotgun. I wonder if it had a grained wood stock or not. Alright, in New Jersey versus TLO, we have a bit of an interesting one here. No decision. It was an anonymous opinion. The Supreme Court restored the case to the calendar for re-argument. So, interesting there. And I kept reading, and it was just saying, like, they didn't really want to take it. They were kind of burnt out on the whole idea of it. Alright, Washington, D.C. versus Heller. In a 5-4 decision, the court held that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia, and to use that firearm for traditionally lawful purposes, such as self-defense within the home, or go to a shooting range, you know. Board of Education versus Earls, in a 5-4 opinion delivered by Justice Clarence Thomas, the court held that because the policy reasonably serves the school district's important interest in detecting and preventing drug use among its students, it is constitutional. So, yeah. Alright, Brandsburg v. Hayes. The court found that requiring reporters to disclose confidential information to grand juries served a compelling and paramount state interest and did not violate the First Amendment. So, Bitsy Bloom from that movie we watched. That's why. Alright, Gideon v. Wainwright. 9-0 majority. The Supreme Court held that the framers of the Constitution placed a high value on the right of the accused to have the means to put up a proper defense, and the state as well, as federal courts must respect that right. Ingraham v. Wright. Teachers can use corporal punishment if your locality allows it. So technically, a teacher could hit a student, so that's a little odd. Alright, Engel v. Vital, or Vitali. Morning prayer violates Establishment Clause of the First Amendment. Neither the prayer's non-denominational character nor its voluntary character saves it from unconstitutionality. So that's a lot of big words in there. Alright, Tinker versus Des Moines. Des Moines. 7-2 majority. The Supreme Court held that the armbands represented pure speech that is entirely separate from the actions or conduct of those participating in it. Yeah, just like protesting isn't illegal, but if it turns into rioting, it is, I think. Alright, Rotary International versus Rotary Club of Duarte. Very boring case, probably. Considering the size, purpose, selectivity, and exclusivity of Rotary's membership, the court found that the relationship among the club's members was not of the intimate or private variety, which warrants First Amendment protection, whatever that means. Alright, Mapp v. Ohio. The court brushed aside the First Amendment issue and declared that all evidence obtained by searches and seizures in violation of the Constitution is, by the Fourth Amendment, inadmissible in a state court. So just throw it out. Alright, Bush versus Gore. It's a boxing match for the ages here. Opinion held 7-2 that the Florida Supreme Court's scheme for recounting ballots was unconstitutional. Even if the recount was fair in theory, it was unfair in practice. 5-4 decision. Close one. First off, California v. Greenwood. Voting 6-2, the court held that garbage placed at the curbside is unprotected by the Fourth Amendment. Second, if you say rise up lights, like you're saying rise up lights, you say that quick, it sounds like you're saying razor blades in Australian. Rise up lights. Rise up lights. See? Try it out. Escobedo v. Illinois. Yes, Justice Goldberg, in his majority opinion, spoke for the first time of an absolute right to remain silent. Absolute right. Escobedo had not been adequately informed of his constitutional right to remain silent, rather than to be forced to incriminate himself. 5-4 decision. I have decided not to get water. Veronia v. Acton. The reasonableness of a search is judged by balancing the intrusion on the individual's Fourth Amendment interests against the promotion of legitimate governmental interests. Okay. New York Times Company v. Sullivan. The court held that the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials except when statements are made with actual malice. Brown v. Board of Education. Very pivotal. Despite the equalization of the schools by objective factors, intangible issues foster and maintain inequality. Racial segregation in public education has a detrimental effect on minority children because it is interpreted as a sign of inferiority. Yeah, it was pretty bad. First, Coker v. Georgia. In a 7-2 decision, the court held that the death penalty was a grossly disproportionate punishment for the crime of rape. Second, if you say, good eye might, so like you have a good eye, might, like you might have a good eye, sounds like good day mate in Australian. Good eye might. See? Citizens United v. Federal Elections Commission. By a 5-4 vote along ideological lines, the majority held that under the First Amendment, corporate funding of independent political broadcasts in candidate elections cannot be limited. Important. Loving versus Virginia. In a unanimous decision, the court held that distinctions drawn according to race were generally odious to a free people and were subject to the most rigid scrutiny under the Equal Protection Clause. Odious. In Schenck v. U.S., Holmes, speaking for a unanimous court, concluded that Schenck is not protected in this situation. The character of every act depends on the circumstances. And he has a cool last name. Apodaca, another cool last name, versus Oregon. In a close decision, the court found that the accused right to a jury trial does not require that juries return unanimous decisions in order to convict. Alright, last one. U.S. v. Lopez. 5-4 decision here. The possession of a gun in a local school zone is not an economic activity that might, through repetition elsewhere, have a substantial effect on interstate commerce. The law is a criminal statute that has nothing to do with commerce or any sort of economic activity. I don't see how that has anything to do with economic activity, bringing a gun to school. So, had to make that distinction early on, apparently.